the rules we adopted today that's very strong, that gives us the authority we need, and that I'm confident will win in court.
I'd like to get some reaction, the congressional reaction to what you've done today. Senator Hutchinson said she was going to try and overturn it in the Senate, and this is what Mitch McConnell said. Today, the Obama administration, which has already nationalized health care, the auto industry, insurance companies, banks, and student loans, will move forward with what would be the first in controlling how Americans use the Internet. Any reaction to either of those things?
You know, we adopted today a strong and balanced order that has widespread support and that focuses on the importance of Internet freedom, the importance of private investment, the importance of business model experimentation. That's why we have so many different people from various parts of the ecosystem supporting it. It's a strong and balanced order, and I'm looking forward to speaking about it with anyone who is interested.
Are there one or more compelling cases under review that the FCC is now looking at that requires immediate action regarding this order?
I think there are complaints that have been filed with us. Those are being looked at.
What can you say about the rules in wireless? A persistent criticism is they don't go far enough.
Well, like a lot of other parts of this, there are people who think it goes too far and people who think it doesn't go far enough. What we try to do is focus on the real issues, the real technological issues, the real differences between mobile and broadband. We have adopted for the first time rules that protect consumers and entrepreneurs when it comes to wireless broadband. The transparency rule, no blocking of websites, no blocking of certain competitive applications. We also recognize that there are ways in which fixed and mobile are different and where more work needs to be done. And as I said in my statement, we'll be paying attention to the pace of innovation and investment in mobile broadband, and we'll be concerned if there's any diminution.
Can you give us just some concrete examples of, not sort of in big lofty terms, but what does this mean for the average consumer going online, both through their wired connection in their home PC and then also through, you know, an iPhone?
In many respects, this is about preserving the freedom and openness of the Internet that has worked for many years. And so we don't expect to see significant changes. What we are trying to head off are changes that would close the Internet, stifle the incredible innovation and investment that we've seen.
Mr. Chairman, do you think that the rules for wireless networks could be expanded or enhanced if at some point in the future the government determines that they need to be put on parity with wired connections?
Oh, well, I think I wouldn't try to predict the future. I think one of the things that we've recognized over the course of this proceeding is that to do our job right, we really have to focus on facts and data. And there's a certain appropriate humility that we should have about technological and business changes. And so we've committed to monitoring all the various aspects of the broadband Internet marketplaces, including mobile. We've set up some structures to make sure that we monitor it. Certainly our great hope is that there's the pace of innovation and openness grows, and that there won't be a need for government action.
Mr. Chairman, with refinements to the order to secure the votes of Commissioners Cox and Clyburn, do you expect to lose any support from industry?
I don't. I think we have a strong and balanced order that serves the public interest, serves the economy. I'm very pleased with where it ended up. I think it's a very good day for innovators, for consumers, for the future of the Internet, and for investment in our broadband infrastructure. Because I said in our statement, we need to have in the United States broadband networks that are both the freest and the fastest in the world. In order for that to happen, we need massive private investment, both at the edge of the network and in the networks themselves. And I believe that what we've done today will foster a reinforcing cycle of investment and consumer demand throughout the ecosystem. That's why I'm so pleased by this, and that's why I think it should have broad support.
Any other questions from members of the Jim?
You heard some criticism about the rush to get this done by the end of the year. Why did you want to get this done by the end of the year? Is it because the Republicans are taking control in the House and you're concerned about the impact of that?
You know, I heard more noise about moving too slowly on the proceeding. This has been open for 14 months. We had comment cycles that closed in October. If you go through the pace and schedule of this proceeding, it followed a very natural course.
What's your response to companies like Netflix and Apple who say this is going to hurt their ability to deliver movies online cheaper than a cable subscription?
Yeah, I'm not aware of that. I think the outcome of this should be to promote consumer investment, innovation, and make sure that there are no unfair restrictions on particular content providers. So I think this will have a very positive effect on the entire internet ecosystem, including the provision of online video.
All right, thank you very much.
Thanks, everyone.
Thank you, Mr. Chairman. We'll now proceed to phase 2 of our press conference, the staff briefing on the 2 items. First, let me ask, does anybody have any questions on the 911 item? Yes. Oh, no. Anything on 911? Thank you very much. We'll now proceed to item number 2, the Internet item. If your chiefs would please come forward. In your questions, if you want to direct it to any particular person, then that might help us move forward, or we can caucus and decide who best can answer. But Lynn, go ahead with the first question.
I was a little confused about how this would apply in coffee shops. It seemed that Commissioner McDowell thought that it would not regulate coffee shops, but Commissioners Baker and someone else mentioned that it would apply to libraries, schools, coffee shops, bookshops.
The rules apply to broadband providers, not to the places like coffee shops that have Wi-Fi connections where it's delivered. So it would be the provider of the service that's subject to the rules as opposed to the coffee shop itself or a hotel.
I've been hearing that there was some clarification in the letter to make clear that in fact it does apply to all kinds of subscribers rather than just service provided to typically consumer type service. Was there anything in the order that?
The clarification was to not who the rules apply to, but who is protected by the rules, and that was the clarification to ensure that schools, libraries, especially those funded by the E-rate program, would be covered by the rules. Not covered by the rules, subject to the rules, but protected by the rules. In other words, as
so does
consumers.
it protect small businesses then, like the opera? Okay. Thank you.
Any other questions? Paul?
I guess the whole panel, I'm curious about whether the FCC's recent finding that broadband is not being deployed in a timely and reasonable manner, as per 706, if that creates a changed circumstance in an appeals court, if a court would look at that differently now.
Sure. What you're referring to is Section 706B. 1996 Act, which directs the Commission to take immediate action to promote broadband deployment if it finds in the mandatory annual review that broadband is being inadequately deployed to all Americans. The Commission did make that finding in July 2010, and that's one of the legal bases relied on in the order. So it's certainly an intervening circumstance that adds to the support for the order.
I just maybe just a little more guidance on what the Commission does consider an unreasonable discrimination. Is that simply a pretext by which people can bring complaints to you, or do you have some more granular means of determining what's unreasonable or not.
There's specific language that we've included in the item that will define what constitutes unreasonable network management. Generally, if there are practices that are targeted for a specific use, like controlling spam or malware and so forth, that would be reasonable. Without judging what cases might come later, certainly things that appear to be discriminatory would be a red flag.
Okay. Paul, go ahead.
I was just, I'm curious, without having seen the text of the rules, could you elaborate on how paid priority services would be treated? It seemed, the rules seem to look askance at paid prioritization, but there seems to be this trigger where the FCC would evaluate paid prioritization. Could you elaborate on the mechanisms in the actual order? How that will work?
The simplest answer is you'll get the rules shortly, but the rules ban unreasonable discrimination and conclude that pay for priority would most likely be unreasonable. It's a very dynamic marketplace with lots of evolutions, so everything will have to be evaluated.
So it's not not a given that a paid prioritization service would immediately fall outside of the scope of the rules.
It's not. I think there's significant concern about pay for priority, and it's not that likely that it would be considered reasonable, but it's not ruled out.
Okay.
Lynn?
Could you talk a little bit about how you envision cases being investigated and adjudicated? If someone brings a complaint, I'm just thinking that the average consumer is not going to have access to all the information they would even know to make the case that it's discriminatory, the information about how things are being done by the company.
We have two types of complaint process. The first is the informal complaint, the consumer complaint. You can simply go to our website, the Enforcement Bureau, you file a complaint online. It's a very informal process. The Enforcement Bureau, in addition to looking individually at complaints, also tracks categories of complaints, the subject matter, the relevant provider, etc. And if it sees trends, then it will either launch investigation based on particular complaints, or it has the authority to launch investigation on its own motion, as it were. Is the answer to the concern the average consumer isn't going to know the details. The second form of process is the formal complaint proceeding, and that's what Free Press, for example, invoked against Comcast a few years ago, where they submitted affidavits, they submitted a lengthy complaint, and that is the kind of proceeding that you see when you have a very well-informed complainant, and for those, the expectation would be we get you to the same place at the end of the day.
Would you expect that individual consumer complaints would get the same kind, or would you expect them to wait until there was some aggregate number before complaints by individual consumers would really get any action at the Commission?
The Enforcement Bureau would treat them in both ways, individually on their own merits, and, as I said, to look for trends, for indication of widespread. So it would be both approaches.
Okay. Anything else from anybody? All right. Thank you very much. Thank you all. And I think this concludes today's press conference and concludes today's agenda meeting. Thank you.